from Valerie Snow from the Senior Law Center. Valerie is an attorney where she leads the Access to Justice and Guardianship Project. She was selected as a 2020 to 2022 Independence Foundation Public Interest Law Fellow and as a 2022 to 2024 Bocard Foundation Center on Law and Aging Fellow, and is grateful for the foundations for supporting her work at the Senior Law Center. In addition to policy advocacy and community education, the Access to Justice and Guardianship Project provides legal advice through the statewide senior law helpline and direct representation, including representation for older adults facing or under guardianship in the Philadelphia Orphans Court. Valerie also serves as a member of the First Judicial District Elder Justice Committee and as a committee service liaison from the Philadelphia Bar Association Probate and Trust Law Section. She is a graduate of the University of Pennsylvania Carey Law School and Haverford College. So as you can see, Valerie has a wealth of expertise and knowledge in this space, and we're ever so grateful for her sharing that with us today. So without further ado, I'll pass it over to Valerie.
Thank you so much, Megan. Just confirming, are you all seeing my front slide? Okay, great. I have two monitors, so I just wanted to make sure. Hi, everybody. Thank you so much for being here today. I'm looking forward to spending a little time with you this afternoon. I would like to make this interactive if you have questions. I know it can be kind of a long time. We don't have to fill all of the time, but I do have a lot of stuff that I can talk about with you, so I'm looking forward to it. Let's review what. Well, actually, first, I wanted to invite everybody, if you have questions that you're coming in here with, or if there's something that you want to get out of this presentation, feel free to put that in the chat, and I'll have Rachel, we'll come revisit that later. Rachel, who's assisting today, will be able to monitor the chat. There she is. And if you do feel comfortable, you don't have to, feel free to share who you are. Are you a patient, spouse, caregiver, adult child, somebody else here, with on behalf of a patient at Penn Memory Center. So I'm going to let everybody think about that for a minute, and then I'm going to go ahead and introduce what we're going to talk about today and Senior Law Center, and a little bit about myself, and then we'll come back to this. So today's presentation, I broke it into two parts because I do want to give a little time for a short break partway through. It's bathroom break, water. But first, I'm going to talk about a little bit about Senior Law Center, just in case folks don't know, and the project that I am leading, Access to Justice and Guardianship. Then we're going to start the presentation with talking about cognitive capacity and how that intersects with the law. Then I'll talk about legal planning for future decision making, including wills, durable powers of attorney for finances and healthcare, and also advanced healthcare declarations or living wills. And then after the break, we'll talk about if people are in more advanced stages of dementia and didn't have a chance to put these kinds of documents in place, what are some alternatives to guardianship, and what is guardianship about? And then we'll also talk about some other common legal concerns that we see at Senior Law Center when people are experiencing dementia. We'll have time to cover a case scenario, hopefully, and get everybody participating, seeing what legal problems and options they can spot. And then I have resources at the end, finding a lawyer, some helpful organizations that may be able to assist, and also online resources. And again, all of these materials will be available afterwards in a PDF, which should include hyperlinks that I include. So Senior Law Center, we've been around since the 70s. We are a legal aid nonprofit based in Philadelphia. We seek justice for older people by using the power of the law, educating community, and advocating on state, local, and national levels. And we are the only legal aid organization in Pennsylvania that assists solely older adults, and one of the few in the nation. We provide legal advice, information, and referrals statewide through our Senior Law Helpline. The number for that is on the next slide. And then we provide all of our services in Philadelphia. In the surrounding counties, we provide some limited services for victim services work, people who've experienced abuse, neglect, or exploitation. But like I said, around the state, we can give free legal information, advice, and referrals. We do not operate outside of Pennsylvania. This is the number for the Senior Law Helpline. Again, it's free, it's confidential, and anybody, regardless of income, is welcome to call the helpline. Our clients are, because we're a legal aid organization, our clients are lower income, but anybody can call the helpline. And then these are some, I know it's a little bit hard to see, these are some of the areas that we help folks in. We have a housing unit for homeowners experiencing all kinds of different issues. Also a landlord-tenant, like a robust landlord-tenant program where we defend older tenants who are facing eviction. Elder abuse and financial exploitation, we help victims of that. Family and kinship care includes custody for grandparents who are raising grandchildren. We have advanced life planning clinics, which I will be talking a lot about advanced planning today. We also help folks with consumer protection issues if they've been a victim of scams, consumer frauds, contractor fraud, and then some other civil legal issues, which does include guardianship defense, which is my project. And if people have a pension question, we are a referral channel for that, so we can help folks with that. So let's talk a little bit about guardianship in Pennsylvania. I don't know how many folks on the call may be familiar with guardianship. Many people aren't, which is completely understandable, but actually it's been in the news a lot in the last year or so with Britney Spears, and there's been more public attention drawn to it. So Britney Spears was under a conservatorship in California, which is the California's state law term for what Pennsylvania calls guardianship, and many states call it guardianship. So in Pennsylvania, there are almost 19,000 adults under guardianship, and about half of those are 60 or older. So this is an issue that affects older adults in our state. Guardianship is when a court decides that an adult does not have legal capacity to manage their own decisions, and they need somebody else to make those decisions for them. So they'll appoint a guardian. It can often be a family member, but sometimes it's a professional guardian whom the person has never met before. A guardianship is a legal stripping of your rights to make your own decisions. So it's a very significant legal matter, and it really should be a last resort because as we'll talk about, the law does assume that adults have capacity until a court decides that they do not. So the Access to Justice and Guardianship Project, as I said before, through our Senior Law Helpline, I can provide advice, information, referrals to any Pennsylvania residents 60 and older. In Philadelphia, I provide direct representation in court, which in Pennsylvania, the court where guardianships happen is called the Orphans Court. It's very, it's from 16th century English law. It's very antiquated. But I also advocate for guardianship reform in Pennsylvania. I do public and professional education. And I just want to note, because we do get calls quite a bit from family members who are asking like, hey, I need a guardianship of my loved one. We don't advise about doing that because we do guardianship defense work, but we can refer families and other people to resources about that. And then on a personal note, I just, because we're here for so long today, and I have a personal connection to these issues. My late dad he had a rare form of dementia called primary progressive aphasia. He actually did, I don't think he received treatment specifically at Penn Memory Center, but he came to the Penn system at some point for some consultations because we have great doctors in the Penn system. And, part of the reason I do this work is because I recognize that if my parents had not had the financial resources and, were in a situation to plan ahead, which they were able to plan ahead when he was diagnosed. If that hadn't happened, he may have ended up under guardianship. And counseling people on these issues and helping people avoid guardianship and retain their rights and their independence as long as possible is really motivating for me. Okay, so now that we've had a little bit of time to take in the introductions, Rachel, I don't, if anybody has put in the chat any of these things, I'd love to hear it. If not, we can just move on.
I haven't seen anything yet, but if anyone wants to share, but yeah, we can just move on maybe.
Okay. Yep.
Yeah.
If anybody wants to unmute and say anything, that's fine. If not, I will move on. Alrighty. So let's talk about cognitive capacity and the law. As I said, the law assumes that adults have capacity. If you're 18 or over, you can move about the world, manage your own affairs. But we all know that capacity can be affected by injury, illness, disability, accident. But on the other hand, capacity is also not an on and off switch. You don't have, for the most part, unless it's a really serious incident, you don't wake up one day and just not have capacity. It doesn't turn on and off. It exists on a spectrum. So you may retain, as with a certain diagnosis or as you age, you may struggle to do certain things like balancing a checkbook or making more complex financial decisions or other types of decisions, but you still are able to, maybe maintain your house or at least name the people that you trust to help you. So there's many different types of capacity. And I really want to emphasize, and I think anybody here in the room will know that just because somebody has a certain diagnosis does not, that diagnosis does not mean that they have, that they're incapacitated. Just because somebody has mild cognitive impairment or dementia, sometimes, there are assumptions and sometimes ageist stereotypes and other things that may lead people to believe that if somebody has dementia that, well, they just don't have capacity, but that's not true. And caregivers and people living with those folks will know that capacity, like I said, really exists on a spectrum. So some of the different types of capacity, the capacity to be admitted to a long-term care facility, to live independently, the capacity to contract, these are all different types of capacity that the law recognizes. And some of these have different standards from each other. So just emphasizing the diversity of types of capacity that exists, and it's not just an on and off switch. Your capacity to manage your finances, your capacity to give informed consent or to refuse medical treatments, to consent to sexual acts, to capacity to make a will, capacity to execute a power of attorney, or testify in court. And the ones that I put a little asterisk next to, I'll be talking about in greater detail a little bit later. You all are presumably associated with Penn Memory Center, and you guys have great clinicians here. I am certainly not a clinician. I am a Pennsylvania licensed lawyer, but not a clinician. Although, of course, my work does interact closely with, I guess, issues of medicine, and I see a lot the intersection of medicine and the law. Medical evidence is one important factor that judges consider when they are making a legal determination of incapacity. And this is an important point, that just because a doctor testifies at a guardianship hearing, for example, all of these things about a patient, and these were the test results, and these are their functional abilities in their day-to-day, and then this doctor has concluded to a reasonable degree of medical certainty that so-and-so is totally incapacitated. Well, the judge doesn't have to just accept that fully. I mean, the judge may find that they agree with that based on that evidence and other evidence, including testimony at the hearing. But ultimately, judges are the ones who decide that somebody is legally incapacitated and not clinicians. But again, clinician, like doctor input is very important, but it's not the end all be all. So some of the types of clinicians that are best suited to provide medical evidence about capacity are psychologists, psychiatrists, geriatric specialties in any of these fields if we're dealing with older adults, and then neurological specialties like a neuropsychologist. And other types of doctors, those are the gold standards, but if a doctor has known a person for a long period of time over their life, it can really speak to their level, maybe a rate of decline or that kind of thing, that can also be valuable. So under Pennsylvania law, like I said, deciding that somebody incapacitated is a legal decision, not a medical one, and as far as the courts are concerned. So this is the legal definition of incapacity under Pennsylvania law. I put it here in full just so folks can read it. It's a little bit wordy, but it basically means that an adult who is not able to receive and evaluate information effectively and or communicate those decisions. Those abilities have to be impaired to such a significant extent that the person is partially or totally unable to manage their financial resources or meet essential requirements for their health and safety. So basically just your cognitive function is so impaired that you're not able to, look out for your finances and your physical health. And some of the things we might look at to see how the person is functioning in the world, and the social workers here at Penn Memory will know these very well, are activities of daily living like dressing, bathing, toileting, transferring, like for example, from a bed to a wheelchair. And then instrumental activities of daily living, which just means basically functioning in the world, as a self-sufficient adult, like paying bills, grocery shopping, housework, managing your money and your medications. So if these types of things are so impaired that the person can't do, the ADLs and IADLs, then a judge may decide that, based on that evidence and the medical testimony, that a person does not have capacity. Here are some elements of capacity that lawyers like myself might know when working with the client. I don't need to go through all of these in detail, but of course, cognitive function like memory problems, if somebody's demonstrating language or communication problems, trouble word finding and expressing themselves, seem to have trouble understanding concepts, whether basic or more complex, trouble considering alternatives, like if I'm asking about, would you like to do this, or what's your priority? Like, are these your priorities, or what are your priorities? And they have trouble with that. Difficulty understanding financial concepts, if they seem to have a emotional distress when we're speaking, of course, delusions or hallucinations, and also observing their grooming, their hygiene, if I'm at somebody's home, like maybe their environment, or also inappropriate social behaviors, just responding to a personal and interpersonal interaction in kind of a strange way. These are some, I guess, flags that might indicate to me that somebody may have diminished capacity. But also, it's very important to recognize certain things may affect capacity, such as medical conditions. One of the biggest things, especially in older adults, are UTIs, can cause serious delirium, and sometimes guardianship petitions have been filed for people based on their UTI condition without that being caught and screened and reversed. So it's really important to consider those types of things. Of course, side effects from prescription drugs, any other reversible types of medication side effects or reversible conditions like UTIs. Also, if somebody's dehydrated or doesn't have proper nutrition, that can affect somebody's mental capacity and mental cognition. Also, keeping in mind time of day. Of course, like later in the afternoon and evening can be challenging for some people, or even early in the morning. If somebody has hearing or vision loss, that can sometimes be misinterpreted for, if somebody's not responding to you, people think that they don't have capacity when actually they just can't hear you. The environment at which any interview takes place, you want it to be as free of distraction as possible, and hopefully a comfortable environment for that person. And also keeping in mind biases that the interviewer, like myself or a doctor, may have in terms of people's different educational backgrounds, cultural or ethnic backgrounds. We're making sure we're not making assumptions and projecting them onto another person if they're coming from a different social background or class background. So like I said, I'm not a doctor, so I hope that if there's any questions here, I'm happy to pause for them, but we'll move on to more legal things. But I did think it was important to talk about how I guess the medical profession sees cognitive capacity and how that intersects with the law, and how we as lawyers use that when we're working on advanced planning issues, and also for me, guardianship defense. So Rachel, are there any questions at this point?
No, I don't see any in the chat.
Okay.
Yeah, no hands.
So I'm gonna move on to legal and financial advanced planning. again, I don't know what people on the call have. Maybe this is going to be basic for you, or maybe not. You know, if this is one of the first times you're thinking about these things. But I can't stress it enough how important advanced planning is, and acting as early as possible is, to avoid problems, expenses, and distress down the road. If you or a loved one has received a diagnosis of dementia of any kind, including, mild cognitive impairment, it probably will be progressive, and it's extremely important to plan ahead, even though acknowledging this and having discussions about it can be very, very emotionally challenging and uncomfortable, but it really will save a world of trouble if it can be put in place early. So of course, talking to lawyers and or financial advisors as soon as possible is what comes to mind when you're thinking about advanced planning, and that's definitely something that can and should be done. And people may approach that in different ways depending on your financial situation. There's plenty of folks that don't have financial advisors or lawyers at their beck and call, but there are ways to receive free services and also lower cost services. I'll talk a little bit about that at the end. But things you might want to do with a lawyer and or a financial advisor are implementing new legal documents. We'll talk about some of those documents, but like a will, powers of attorney, healthcare directives. If you already have documents, looking at those and revising them depending on when they were last revised. Financial planning for long-term care is really important. And if you have a lower income, don't assume that this is not for you, because do you own a house? Do you own a car? Do you own, an insurance policy? Even if you have very little income or savings, you're going to want to think about planning ahead, even in terms of government benefits available, like Medicaid, and how to navigate the process now to set yourself up to be able to qualify for those programs when you need them. If you do have more resources, sometimes creating a living trust is something that's done. We don't do that at Senior Law Center. We do, that's sort of beyond us, so folks would need to seek a private attorney for that. But other things that you might want to do with your legal or financial professionals are reviewing insurance policies, beneficiaries of those policies, and or payable on death designations. And then finally, thinking ahead to probate of an estate after death, or avoiding probate. A lot of people want to avoid probate, so it's best to talk to a lawyer about all those considerations. Advanced planning, though, goes beyond just talking to legal and financial professionals. It should also include discussion with your family members or other close contacts about what your wishes are. This is so important because, like I said, I know it can be hard and uncomfortable, but it will really save a lot of distress on your loved ones if in the future, if they know what your wishes are and they're able to act on them, rather than them having to decide, well, what would mom would have wanted? I don't know, we never talked about it. And then maybe the children having to make that decision and that putting a burden on them. So talking about healthcare provision wishes, living arrangements, for example, I do not want to go to a nursing home. Let's do everything we can to keep me home as long as humanly possible. That's a really common request. What are your wishes for end of life decisions? Do you want to be kept on a ventilator even if you are not going to recover? Or do you just want to let nature take its course, for example? What are your burial and funeral arrangement preferences? And also, if you were to pass, what would you want to happen to any dependents or pets or anything like that? So these are important things to think about. You also want to start gathering and documenting important information and storing it in a safe place at home, and letting your trusted contacts know where that is so that they have access to it when they need it. And then think about setting up, you may already have things like this, but automatic bill payments online so that you don't have to write checks as somebody might be declining. Adding a view-only designation if your loved one with dementia has a sole bank account. And this is a designation that many banks have where, say, adult child can just view to make sure that bills are getting paid or that there's nothing suspicious going on. Sorry about that. And then also medication management programs is something to consider. Okay. In addition, if you can identify service providers now, for now or for in the future, that will take some burden off later of having to identify these people when you really need them. But if you can afford a geriatric care manager, that is often very helpful, or a care coordinator, they're called sometimes. That can be expensive. However, some places do operate on sliding scale fees, but unfortunately not everybody has access to those types of services. An adult daycare program nearby, if your family's open to that. Maybe identifying home health aides or agencies that you would want to use in the future if that's needed. And of course, if you were needing to go into an assisted living facility or a nursing home, identifying, I definitely don't want to go to that place. That place is a dump. Those kinds of things. And then finally, seeking out formal and informal supports, because these types of diseases are really trying on, of course, the person who has it, but also everybody in their family and extended networks. So just bringing together to the extent that we can, especially we're still in sort of COVID times, seeking the support of friends and family, community organizations, maybe getting involved in some community organizations to keep yourself networked and avoid isolation. That could include religious institutions, and even seeking out counselors or therapists, even if it doesn't even have to be psychological therapy or counseling. It can include, physical therapy, occupational therapy, speech therapy. And then finally, there are numerous support groups. There may be, I think there are some at Penn Memory Center. This probably counts as one, but also Alzheimer's Association has support groups, and there's some other organizations that have support groups. So seeking those out. And so why is planning ahead legally and financially so important? I really want to, I've been telling you it's so important, and it is. And let's talk a little bit about why, because you're putting the person with a diagnosis in the driver's seat. It's very important to keep, we at Senior Law Center always use a person-centered approach, a holistic approach. The person with a diagnosis, you want to make sure that you know what their wishes are and know what their preferences are, and that those can be respected in the future. And that's what the person with the diagnosis wants too. They want to make sure that people aren't guessing about what they want, and that they make it known. Any of the legal planning documents that we're going to talk about, which I've mentioned, they can be changed or revoked by the principal. So the principal just means the person who is making the document for themselves, who is signing the document. The principal can revoke or change any of these documents as long as they continue to be of sound mind. And that's a really important benefit of putting these documents in place in advance, because if you get to the stage where unfortunately a guardianship is needed, which the court imposed guardianship, you can't just opt out of it. Only the judge can terminate it, even if you don't agree. So putting these documents in place in advance helps you retain your agency. And if something happens where you no longer trust somebody to serve as your agent under a power of attorney, you can revoke that, or you can get somebody else to serve. And then, of course, each document can be customized. You can add or remove provisions according to what your wishes are. And it helps avoid legal problems later. As I was saying, think ahead in terms of if somebody needs to interact with a bank, and my mom banks at Wells Fargo, and she's the only name on the account, and then she has advanced dementia, and I go in and try to manage some issues for her. If I don't have any type of authority, if she hasn't designated anything in advance, they're not going to talk to me. Same things with, insurance companies, landlords, mortgage companies. Think about who's going to act on your behalf in all of these types of situations. And that includes with some healthcare decisions too. So I just really underscore it here. Would you rather have the law decide for you by default who makes your decisions or who inherits your estate? Think about somebody you've never met, a professional guardian making decisions for you. Now, the professional guardian should be acting only in your best interest and following your wishes to the extent that you can express them. But the quality of guardians really varies. We have some, guardianship is still, there's a lot of areas for improvement here in Pennsylvania. And I think most people would agree that they would prefer not to have somebody they've never met suddenly in control of a lot of important decisions in their life. And also the law will prioritize who inherits your estate by default. The law could decide that an estranged family member gets your entire estate after your death, just on the basis of biological relation. And that also goes for some healthcare decision makers. If you don't name a healthcare decision maker in advance, the hospitals could turn to, your spouse whom you've been separated from, but not legally, and they live, you're on terrible terms, and you just never got divorced, you never got separated. Your spouse is still your spouse. The hospital could turn to them, but that's not what you would want because you're kind of estranged from them. So these are examples of when I guess there's unintended consequences of not planning ahead. So Senior Law Center helps folks mainly in Philadelphia who meet income requirements to draft the following type of documents. A simple will. We can't do complex estates. We'll refer you to an estate planning attorney. But simple will, financial power of attorney, healthcare power of attorney. Sometimes lawyers combine those two. That's fine. We just separate them out. And also a living will or advanced healthcare declaration. Like I said, we don't engage in complex trust and estates work. And each document does require formalities to be executed. Formalities meaning you need to sign, of course, have witnesses, and notarize. Not all of the documents do require notaries, but we do it just, we want to make sure everything can't possibly be contested on the basis of the execution of the document. So we have everything notarized. And I want to really emphasize, folks on the call, please do not go onto online resources and try to print out a power of attorney document and just do it at home. And I'm not only saying that because I'm a lawyer, and presumably I would want you to use our services, but no, the reason I'm saying that is because the forms are often incomplete, which means they're not valid. They may have been updated. You don't know when they were necessarily updated. You don't know when the law was last updated and if they comply with those changes. So it can really be a pitfall. And unfortunately, I've seen it quite a few times where we can't actually talk. Somebody approaches us and they say that they're the agent under power of attorney for their older adult relative. And we may be able to talk to them under certain circumstances, but we have to review those documents first. They send over the document to us. We look at it. It's a form from LegalZoom or something, and it just is missing, the required statutory notice that informs people of their rights. For example, it's like, well, that's not a valid document, unfortunately, so we can't talk to them because, it's not valid under the law. And in addition to the validity, using the services of a lawyer can ensure that the document is customized and tailored, and you can receive counseling about how to work the document in a way that works best for you. So wills, the capacity to execute a will is actually less than the capacity to conduct business or to enter into a contract. People may be a little bit surprised about that, but you just have to be of sound mind and know the following things: the identity of your closest relatives, the general composition of your estate. You don't have to know every single asset, and also what you desire to do with the estate. Those things are all really integral to making a will. So assuming you are able to name all of those things, of course, a will is the only planning document of the four that I'm talking about that has effect after death. A will serves to name an executor of your estate. That just means the person who's going to do all the business after your death of wrapping up your estate, filing any taxes due, transferring property into the names of the people you choose, that kind of thing. The will empowers the executor to act on your behalf after your death. The will disposes of property in accordance with your wishes, including real estate and personal property. And it identifies beneficiaries of your property and plans for worst case scenarios. So for example, if you want to leave your entire estate equally to your two children, if one of your children unfortunately predeceases you, if they die before you, what's going to happen to their share of that, of the money that they were going to get? Is it going to go to your grandkids? Is it going to go to the others, to their brother or sister? So there's a lot of ways you can structure this. Although it is certainly best to execute a will completely and formally and have the notarization and all of that, but we do also have a info sheet that we can provide to people who want to make a holographic will, and that just means it's a will that you sign at the bottom, and it has all of the above information, but it's not, it will often be accepted by courts, but it's not the safest way to go. But we can provide information about making holographic wills to folks. Sometimes we get that request when people are going on a big trip and they're just nervous if something were to happen to them, and they want that in place just for peace of mind. But when they get back, they're going to make a will with all of the formalities. And again, if you don't have the capacity to make a will, if you're not of sound mind and don't know those things, then unfortunately there's no way to make the will after capacity is lost. After your death, your relatives or whomever, if they want to, will need to administer the estate. It's called an intestate estate. That just means that there was no will, but they'll have to apply to administer the estate, and there's a couple more hoops to jump through. So having a will also save headache for whoever needs to administer your estate. Financial powers of attorney are, you all know what these are, and they can be really, really powerful documents, and that can be a good and a bad thing. Sometimes powers of attorney are referred to as like power to steal, and that is, of course, illegal. It's against the law. You can be charged criminally and sued civilly for it. But I just say that to emphasize that a financial power of attorney is a very legally powerful document, but it can really save, it is one of the most common alternatives to guardianship, and it allows you to name somebody whom you trust to manage your legal and financial affairs on your behalf. So that does require a higher standard of capacity. One thing I want to emphasize that we hear all the time, family members call Senior Law Center and say, I want to get a power of attorney for my dad. He has dementia. No, he can't talk to you. He wouldn't understand. Unfortunately, we can't help those people. The dad with dementia would have to be the one directing the power of attorney to be made. He would have to understand the nature of the authority that he's going to delegate, the nature of his estate and his assets that he owns, and he would have to just understand all the language in the document and what its implications are. So you can't just get a power of attorney for a relative who has already lost capacity, unfortunately. But that's kind of a common misconception that we hear. Powers of attorney can be durable or springing. I'm not going to spend too much time on this just because durable powers of attorney is really the way you want to go, especially if you have a diagnosis where you're probably going to decline. Durable just means that the power of attorney document remains valid even after you lose capacity. And I think that's what most people think of when they think of a power of attorney anyway. The whole point is so that when you don't have the capacity to act on your own behalf anymore, that your trusted people can do it for you. A springing power of attorney means that it only takes effect when you lose capacity. Some people like that if they only want this document to go into effect when their doctor says so-and-so really has lost capacity and can't do it. They see that as a protection from maybe relatives acting beforehand, but it's not always recommended. So the power of attorney document names and empowers an agent. Your agent might be a relative, for example, and when you're drafting it, the lawyer should go through with you these things called hot powers, and they're really important powers that Pennsylvania law offers an agent. They don't have to be included, but these are examples of things that the person making the power of attorney would have to be able to understand whether they want that or not. And it includes rights such as your agent, let's say it's your adult daughter. Your agent could change a beneficiary designation on your insurance policy, or your agent could delegate their powers to somebody else. Your agent could make gifts on your behalf, meaning, money gifts. So do you want your daughter to be able to donate to the charity that you've donated to for 50 years? But keep in mind, and you can limit that. If you give somebody unlimited gifting powers, they could just take your money and give it to their friend, and there's nothing that can be done because you didn't restrict that. So having the wherewithal to understand those kinds of decisions. An agent under a power of attorney has to keep your money and their money and property separate from each other. You can't commingle because you want it to be clear whose money is who. the agents have to keep an accurate record of the actions that they're taking. They have to keep their receipts, a log of their receipts and transactions. And they also have to exercise reasonable caution and prudence. So just being careful, not to dump all your money in Bitcoin and hope it works out, that kind of thing. And power of attorney, even if you were to sign it today, it doesn't have to become effective now. So that's actually something that a lot of people like to take advantage of. The power of attorney is not effective until the agent signs an acknowledgement page. So you can execute a power of attorney document today, and you can give a copy to your son or your daughter. They can keep it in a drawer. And then maybe in 5 years, when you feel like, well, I'm starting to miss things, I have some bills that aren't paid, I feel like I need help, then you can call up your son or daughter, whoever is your agent, and say, hey, remember that power of attorney? I want you to act as my agent now. Can you please get it out and sign the acknowledgement page? And from that point, your agent has the power to act for you, but not beforehand. So an agent can't go around using the power of attorney unless they've signed that acknowledgement. So that is one way that people can plan ahead without having to have the power of attorney go into effect now. And just remember that powers of attorney, unlike guardianship, you still have the power to act on your own behalf. You're just also giving that power to somebody else. You're not totally giving up your own powers to do things. Okay, and then for healthcare decision-making, sorry, my slides are, there we go. Healthcare power of attorney. Under Pennsylvania law, the level of capacity required to execute a healthcare power of attorney is not very clear beyond of sound mind, but presumably you'd want to, the lawyer who's drafting it with you would want to make sure that you seem to be understanding the language in it and what it means and the consequences. A healthcare power of attorney only takes effect when a physician determines that you're not competent to make your own medical decisions. So doctors will always come to you first, and it's only if they determine that this person really, can't make informed consent, they're not understanding. At that point, they will turn to your agent whom you've listed in the healthcare power of attorney. And the document names your agents and empowers those agents to do all kinds of things regarding your healthcare and your services that you're receiving. This does include the ability to place you in a care facility, although you can remove that if you really want to. But thinking ahead about it with a lawyer is important. Of course, giving them HIPAA access. And this document, once you execute it, you really want to share it with your doctors or other care providers so that they have it on file and they know who to contact if they need to. And that's the same goes there for the living will or the advanced healthcare declaration. You want to make sure you share that with your doctors and care providers once you've done it. Just as with the healthcare power of attorney, the level of capacity that you need is not clear beyond of sound mind. But keep in mind, this only takes effect when you have an end stage medical condition or are permanently unconscious. This is a document that helps you document your end of life decisions and preferences. A lot of people get pretty squeamish when we break out this document, and of course they don't have to complete it, but they see things like, do you want CPR? Do you want ventilation? Do you want tube feeding? Do you want blood products or dialysis given to you? And a lot of people say, well, I mean, yeah, like I want the doctors to treat me, of course, like I want to get better. And that's a completely valid sentiment. But we always say this document is only going to take effect when you are terminal. You are not going to get better. And any measures taken under this document are only going to serve to prolong the process of dying. So that's important to remember, that you're not signing off on, foregoing all medical treatment from now on. This is really just, some people have very strong preferences about, I just want to go when it's my time, or other people feel I want all measures taken to keep me alive for as long as possible, even if I'm not conscious. So we're going to take a short break next, because we're coming up on, I guess, almost an hour. It's 12:50 or so. And then after the break, we're going to talk about what happens when it's too late to put these documents in place. If your loved one is not early in the process, in the dementia sort of progression, if they're later in the progression, what can you do if you weren't able to plan ahead? But first, Megan, sorry, Rachel, are there any questions?
Nope, I don't see any questions.
Okay, if anybody wants to unmute themselves or if anybody thought of a question, please feel free.
Sounds
But
good.
otherwise, I guess I'll turn my camera off briefly and we'll take a 5-minute break and we'll get back here at 12:55. So I will see you in a couple minutes. Thank you. All right, it is 12:55. Rachel, can you just check the chat for me?
Sorry, what'd you say? I just came back.
Oh, sorry. I was just saying it's 12:55 and I just wanted to know if you could check the chat for me.
Oh yeah, absolutely. No new messages.
All right. So we're gonna continue. Hopefully folks are back. Let's talk about what happens if your family, your loved one has progressed past the stage where they're able to put those documents in place and they no longer have the capacity to execute those documents. So if the dementia is already in a later stage, for healthcare decisions in Pennsylvania, and again, I apologize to New Jersey, Delaware residents, that kind of thing, there may be a similar provision in those states' laws, but I'm only licensed in Pennsylvania, so I'm going to be talking about Pennsylvania. But for healthcare decisions in Pennsylvania, a family or close friend can serve as a Pennsylvania healthcare representative, or the medical field sometimes calls it Act 169 representative after the legislative bill number. This takes effect when if a patient is incapacitated. Let's just take a hypothetical of an older man in the hospital. If the doctors determine that he is incapacitated, and if there's no existing authorization that they know of, like a healthcare power of attorney or a legal guardian, if they don't have anything on the file, they can turn to a specific priority list of people in the patient's life who may be able to step in and make those informed consent medical decisions on their behalf. So the good thing about the healthcare representative, which only came into effect in 2006 in Pennsylvania, is that there's no need for a document or a court order or anything like that. It can take effect in the absence of all of those things. So it is an alternative to guardianship that I have used to, successfully get guardianship petitions dismissed, because there is somebody available to serve as the healthcare representative. So who can serve as the healthcare representative? Well, I put this priority list here. The law goes down the list of people. So if you have a spouse, they're going to turn to your spouse unless there's a divorce pending. And also your adult children. They look to the spouse and the adult children to, the little nucleus of people to make an informed consent decision, for example, on behalf of the patient in the hospital. Or any other care facility setting. I'm just using the hospital as an example. If there's no spouse, then, I'm sorry, the adult children who are not children of the current spouse. So it's, if it's your second spouse, they're gonna look to your children from your first marriage, but otherwise they're just looking to your spouse. And then if you're not married or widowed or something like that, they're gonna look to an adult child. If that's not available, looking to a parent. That may not be relevant for older adults, but certainly for younger people, they may look to an adult sibling. After that, they'll see if you have any grandchildren. If none of those people exist in the patient's life, then any adult who has knowledge of the incapacitated person's preferences and values, that includes moral and religious beliefs, can be a really close friend, maybe, college roommate or somebody you grew up on the block with, who you've been friends with for ages, and you consider them like a brother or sister. That person may be able to serve as a healthcare representative if those higher priority people are not present. And the healthcare representative has all the same rights to access your medical records and to make medical decisions on your behalf as an agent under a healthcare power of attorney would. So it's, in my opinion, it's good that this was put in place in Pennsylvania so that doctors didn't have to go seek a court guardianship just to make, authorized surgery or something for a patient, because if they have somebody in their life they can turn to as a healthcare representative, that solves the problem. For financial planning, and by the way, I wanted to mention the healthcare representative, you can also, even if you've lost the capacity to make a healthcare power of attorney, if you still can say, I trust my daughter, I want her to make these decisions, you can still tell your doctors that and ask them, you and your daughter and your doctor can talk about naming your daughter as your healthcare representative in the medical records. And that way folks know that she can serve as your healthcare representative. So you can name it in advance. But again, it doesn't require a document, doesn't require a court order. So for financial planning, if the person's only income, and this is the case with many older adults, but if the person's only income is Social Security benefits of any kind, then somebody can serve as your representative payee through the Social Security Administration. And this is a really great alternative to guardianship as well, because it doesn't require you to have a power of attorney. But again, it's just for Social Security benefits. So a representative payee is somebody who essentially acts like an agent under a power of attorney, but just for the Social Security Administration. That person receives your benefits on your behalf, has to spend it only for your benefit and your care, has to document their transactions, things like that. A lot of people don't realize that the Social Security Administration, as a federal agency, it doesn't recognize state-based powers of attorney. So, if your sister is your agent under power of attorney, that's great, but she's going to separately also have to go through the Social Security representative payee process in order to handle benefits on your behalf. And there's also a way, by the way, and it's in my resource slide at the very end, but there's a way to designate somebody in advance that you would want to serve as your representative payee in the event that you become incapacitated. So that's another good way to put things in place in advance in accordance with what your wishes are and not wait for the decision to be made for you. So unfortunately, though, for finances, unlike healthcare, for a lot of healthcare decisions, a healthcare representative can be fully sufficient if one exists in your life, and you're past the point again of making these documents because you've lost too much capacity. Unfortunately, for finances, there's a lot more complexity and a lot more types of things that need legal authority to act. And not everything is just going to happen with your Social Security benefits. So in some cases, a court-ordered guardianship may be necessary, but it should be the last resort. So I'm not here to say that guardianship is bad in all cases, or that it's even bad at all. It can be used very responsibly. It can be used because it's necessary, but it should be a last resort just because it really does strip people of their legal rights to manage their own lives. And also want to add that it's expensive. Hiring an attorney to file guardianships, again, Senior Law Center, we are a legal aid organization, but we don't do that because we only do defense, and there's very few organizations that will file guardianship petitions for free. It can be a long process depending on the court and the judge that you're in front of, and it's also quite a burden to be a guardian. You have to file annual reports, you have to keep meticulous records, you have to do everything on behalf of that person in accordance with their wishes and for their best interest. So it's really best to avoid if possible. Let's talk a little bit about guardianship. I don't know that everybody on this call is going to be, hopefully a guardianship won't happen to anybody here or anybody's loved ones, but I think it's worth talking about it because it can happen if advanced planning is not arranged. So guardianship, like I was saying in the very beginning, and I know we had a couple people join us since then, think of Britney Spears, right? Guardianship is when a court decides that you're incapacitated, can't make your own decisions about your finances and your health, and appoints a guardian. So here's some terminology that is commonly used in this area of the law. A guardian of the person. So there's two types of guardians, and it can be the same person. Let's just make it easy, and let's say that the same person is serving as your guardian of the person and your guardian of the estate. A guardian of the person is responsible for your healthcare and personal care, including medical consents. This also includes living arrangements, so deciding when you need a higher level of care and maybe placing you in a nursing home, even if that's not your wish. Obviously they should try to follow your wishes, but ultimately they do have the legal authority to, decide on your living arrangements. And also arranging social and other services for you. A guardian of the estate is responsible for paying your bills, for managing your income. Even a guardian of the estate has to go get Social Security representative pay status, dealing with your pension, filing and paying any taxes that you may owe, managing your real estate, home upkeep if you're staying at home, and your personal property. So the guardian of the person and guardian of the estate, which again we're pretending like they're the same person because they often are. It's really a huge amount of power over things that most people consider essential to their lives. the guardians can be plenary, which just means full powers. They have like full authority to act within those two domains, or they can be limited guardians where it's limited to, this guardianship is limited to, for example, selling somebody's primary home and placing them in a nursing home. It can be limited to that. In practice, unfortunately, it's not often limited. It's usually plenary, so giving people full authority to act. An emergency guardianship is it's used on an emergency basis only. It does take less amount of time. It's supposed to be expedited, but it's not just a way to get around the whole guardianship process. You really have to show that there's going to be irreparable harm to the person or their estate. And it is time limited, so you can't just have an indefinite emergency guardianship. You have to go back to court and extend it and show reasons why it needs to be extended. Some other legal vocabulary that I just want to mention up front, because it's everywhere in the law. I don't always love this vocabulary, but as I was saying, orphans court, that's the court where it takes place. Every county, for the most part, has an orphans court. Some more rural counties in Pennsylvania like share a court system. But I work in the Philadelphia, I practice in front of judges of the Philadelphia Orphans Court. And the other terms are AIP and IP. That refers to alleged incapacitated person. That is somebody who is the subject of a guardianship petition, but has not yet been determined to be incapacitated. So somebody's making an allegation that you're incapacitated. And then incapacitated person is somebody who has been adjudicated as lacking capacity, and a guardian has been appointed for them. I don't like those terms. They're from the early 1990s, and I find them pretty stigmatizing, but unfortunately that is the language that's used in the law. So we do use it, but I usually like to refer to clients that I may have as people who are facing guardianship or under guardianship. So how does a judge decide to place somebody under a guardianship? They're only going to appoint a guardian and place somebody under guardianship if, after considering all the evidence, which includes medical evidence, the judge determines that the adult is partially or totally incapacitated. And also, this is crucial, it's an and, not an or. Also, the adult needs a guardian because there are no viable, less restrictive alternatives to guardianship. So just because somebody doesn't have capacity doesn't mean that you can automatically place them under a guardianship. You have to go through and say, are there any alternatives to guardianship that exist here that would prevent, that would solve the problem we're trying to solve and prevent people, prevent us from having to put a guardianship in place. So a healthcare representative, I gave that example as one, getting I got a guardianship dismissed based on the hospital was seeking a guardian because they thought that my client was incapacitated, but there was somebody who was able to serve as a healthcare representative, and I pointed this out. That person consented to my client's discharge to a facility, acting as the healthcare representative, and then the hospital withdrew their guardianship petition. So that's an example of where, even if that person is incapacitated, there was an alternative, so we didn't need to use guardianship. So I just put an example here, like if there's no legal documents in place, there are no surrogate decision makers available. Unfortunately, I do have quite a few clients who have nobody at all in their lives, whether those people have died or moved away or they just didn't exist to begin with. So if there's nobody to make decisions on their behalf, there's no pre-existing legal authority, and there's some legal or financial decision that needs authority to act, then a guardianship really may be necessary. But again, it's a serious matter, should be a last resort. I've broken record here, but I can't really say it enough. Just emphasizing the powers that the guardians have. They can decide where people live, how your income is spent, how your Social Security income every month is spent, how to manage your property, whether you're going to sell the house, whether you're going to sell personal belongings, put it in storage, consenting or objecting to medical treatment. And also, once somebody is labeled as incapacitated and loses their rights, they're not allowed to sign contracts on their own behalf, sign legal documents. Basically, the guardian is now, legally speaking, acting on your behalf, so you can't sign your own legal documents. The guardian does, of course, have a fiduciary duty to act for the benefit of the adult, cannot do things to enrich themselves, at their clients, to the detriment of their client. So they're supposed to be acting in the person's best interest and according to their wishes. But like I said earlier, there's a variable quality of guardians, and if we can avoid getting to a guardianship, we really want to. So what does the process look like really briefly, just so it's a little more concrete for folks? So a typical guardianship, a petitioner drafts the guardianship petition. Oftentimes the petitioners are hospitals, nursing homes, sometimes family members, and also sometimes protective services like older adult protective services may file a petition for guardianship. They should file it with medical evidence, or a doctor is going to testify at the hearing. So the guardianship petition is filed, then the judge schedules a hearing and orders the guardianship petitioner to notify the adult who is, the subject of the petition. The judge may or may not appoint an attorney to represent an adult in the proceedings. I think there's a push in Pennsylvania, and it's already the case in many other states, that attorneys are mandatorily, they're automatically appointed to represent the adult facing guardianship, because you do stand to lose a lot of rights. So in my mind, I can't understand why you wouldn't appoint an attorney to advocate for that person, because we already do appoint attorneys to represent, for example, criminal defendants who can't afford one, or that kind of, there's about probably 10 other areas of the law where we automatically appoint attorneys. But anyway, regardless of whether an attorney is appointed, there will be a hearing. The purpose of the hearing is to decide whether the adult is incapacitated and whether they need a guardian. If so, the judge then orders the guardianship and appoints the guardian. And then after that point, the guardian has to submit annual reports to the court each year. A guardian of the estate who's dealing with the money has to submit an inventory as well. The court will then monitor the guardianship until it ends. And that, unfortunately, it's often ends at death, or it can end when a judge terminates it. So once in a while, we at Senior Law Center do represent people who have been found to be incapacitated, but have recovered their capacity or don't need a guardian anymore. And we're able to terminate that guardianship and restore their legal rights to them. But it's kind of an uphill battle. And if you can avoid getting under a guardianship if you don't need one, that is really the best. And a guardian can be paid. I just want folks to know that they can be paid from the estate of the person whom they're serving. Even if you don't like that guardian, the guardian can ask for fees from the court. And if you have the money, the court will order the fees from your estate. If you don't have the money, they might order the fees to be paid from the county. And like I said, guardianship often continues until death or until the court says so. So people facing guardianship and also under guardianship do have rights. People facing guardianship have more rights. Of course, they have the right to receive notice of the proceeding. They can hire a lawyer to represent them, or they can ask the court to appoint one. They have the right to attend the hearing. They really should attend the hearing. They also have the right to request an independent medical evaluation if they disagree with the medical evidence. And of course, they can appeal the final decision. If somebody is already under guardianship and a judge has appointed a guardian for them, the rights are more limited, because as I said, that act means that you are being stripped of your legal rights. So once you're under a guardianship, you have the right to express your wishes and your preference to the guardian, and the guardian should try to honor it as much as possible. You have the right to ask for a review hearing to either replace the guardian or to modify the terms of the guardianship or even to terminate the guardianship. You have the right to hire a lawyer of your choice to challenge the guardianship, even if you're not able to pay. If it's a different legal issue that you're having that's not related to your guardian will represent you in those legal issues. The only time that you're really going to hire an attorney if you're under guardianship or choose an attorney is if you're trying to challenge the guardianship. And then, of course, you have the right to receive necessary medical care, psychological care, social services, obviously to be, the right to be looked after. That's the whole point of a guardianship, in theory. So to remove or terminate a guardianship, the only way to do that is to go back to the same orphans court that put you under the guardianship and request a review hearing. There are some legal grounds in Pennsylvania law that merits a review hearing. So a change in circumstances, saying that a guardianship is no longer necessary, is a big one. Maybe you've regained capacity after a stroke, for example. or maybe now you're receiving services that you didn't have in place before, and now you really can manage. Even if you're incapacitated, you might not need a guardianship. Or like I said, maybe you've regained capacity. Another reason for requesting a review hearing is if the guardians failed to perform their duties or they haven't acted in your best interest. In that case, the guardian can change. But it's strongly advised to hire a lawyer or to ask the judge to appoint one for you if you're trying to challenge anything about your guardianship, because it's really not accessible. And particularly if you're somebody who the court has said that you're incapacitated, it's fortunately not likely that you're really going to be able to navigate this successfully without the help of a lawyer. But that's something that, that I do at Senior Law Center, is representing people who are facing or under guardianship. I've mentioned a few times, alluded to the fact that we have some areas we need to improve in our guardianship system in Pennsylvania. There's probably many systems that need to be improved in many ways in Pennsylvania, and guardianship is one of them. There's not an automatic right to an attorney, as I was saying before. That is a push in the Pennsylvania legislature right now, actually, something that I for one am excited about if that were to pass, because I think everybody facing guardianship should have the right to have an attorney appointed automatically. And sometimes, and this was especially the case before COVID, because actually I've always done my guardianship hearings on Zoom. The guardianship hearings are continuing to be on Zoom, even though other things are, this is for Philadelphia, I should say. There's other counties that do things differently, but in Philadelphia, the judges are still holding guardianship hearings on Zoom because often my clients are in a hospital or a nursing home, and it does permit them to be present, whereas they wouldn't have been able to get to the courthouse otherwise. So that's a good thing. But especially before COVID, a lot of times people weren't present because they weren't in a hospital or a nursing home. We have an issue that there's not enough qualified professional guardians to serve. And that's partially because of the how things are structured in Pennsylvania. There's not good sources for payment for the professional guardians. And it is a tough job, but we also really do need more of them. In my opinion, we need a public guardian run through the state. Many states do have that. And some of the states with the best types of guardianship systems, the public guardian is really an essential part of that. We also don't have enough training or help for family guardians, like family members serving as a guardian, to help them understand what their obligations are, to help them file their annual reports. There's inconsistent oversight of guardianship reporting. So from county to county, Philadelphia has a few guardianship investigators now, but that's within the past couple of years. And there's other counties that, do things very differently. So it's inconsistent in how the guardians are being monitored, like if they're stealing from their clients, which, hopefully is not common, but it's not consistent the way guardianships are monitored. And then finally, it can be difficult to find help once you're under a legal guardianship. There's not a ton of attorneys who will represent you to try to overturn the guardianship.
Valerie, we actually have a few questions. I was wondering if you could take a second to answer some of them. Is that good?
Yeah.
Okay, great. So our first question is just wondering, is there an organization similar to PA Senior Law Helpline in the state of New Jersey state of New York that you know of? I live in PA, but my family lives in New York, and I'm trying to assist them from afar with figuring out what paperwork we need to do. I want to talk to someone knowledgeable there in New York to find out if there's a similar law to Act 169 PA healthcare representative operating in NY.
Yeah, sure. So I'm going to talk about this a little bit at the end. So there's something that exists in, I think, probably every state. I'm sure that New York will have in Pennsylvania, there's a lawyer referral service. And I'm sure it exists in New York too. Every state that I've ever checked has this. So I would recommend going to the, I don't know what county your relatives live in, but let's say they live in Kings County, New York. You go to the Kings County Bar Association website, or you type in Google Kings County Lawyer Referral Service or Kings County Bar Association Lawyer Referral Service. You can get I don't know if there's something similar to the Senior Law Helpline, which is free, but the lawyer referral service, you can have it's usually a half-hour consultation with a lawyer for a very reduced rate. In Pennsylvania, it's often about $30. And you don't have any obligation to hire that attorney, but you can have a half-hour consultation with an attorney who's knowledgeable in this area of the law in New York and ask them all of your questions, including, you know, is there a law in place similar to this Pennsylvania healthcare representative? And again, you don't need to hire that attorney for anything. You just have to pay the small fee for the half-hour consultation. So for the kinds of questions it sounds like you might have, that would be a really good place to start, is going to either the New York Bar Association lawyer referral service, like the New York State one, or the county one, because most of the bar associations run these lawyer referral services.
Great, thanks. And the next question is, what are your thoughts on funeral and burial pre-planning when the individual does not need a guardian? Alternatively, should this just be stated in a will or a trust?
Yeah, great question. It's a great idea to do funeral burial pre-planning. If folks do have the money to set aside for that, there's even just bank accounts that are like irrevocable burial accounts where you can put money in, and then that money's not going to be counted if you're trying to qualify for benefits or something like that. But it's a good idea. Yeah, planning ahead either directly with the funeral home or just having that designated account. That can help family members when they're, you know, grieving because somebody in the family's just passed. It can help them with planning and not having to deal with all of those difficulties. Was that the whole question, or can you read the question again?
Yeah, I think you did. What are your thoughts on funeral and burial pre-planning when the individual does not need a guardian? Alternatively, should this just be stated in a will or a trust?
Oh yeah, so you certainly can state it in a will or a trust, and you can also state it in your advanced healthcare declaration, your living will. There's a chance to make a personal statement. Honestly, it's best to, you know, even though you can put it in a will, and many people do, the will is often, I guess, maybe comes into the picture a little bit too late. Because it's often at least several days after death, and maybe folks want to know what they're supposed to do earlier. So I'd recommend, you know, making the arrangements ahead of time and talking to your family members about it, letting them know where that information is, but you can definitely put it in the documents.
Mm-hmm. Great. Okay, two more. How often does an elder law lawyer act as a financial and healthcare POA for unsupported adults? How does one weigh that choice versus using friends who may not be extremely close, or close friends may be too busy or far away?
Yeah. The issue of people who don't have a lot of natural supports in their lives is a really challenging one. So nobody at Senior Law Center, myself included, we don't serve as an agent under a power of attorney for anybody else, but there are attorneys who do this. I think also some banks or trust companies, there's some places like that are corporate fiduciaries, they're called, that can serve as like a financial power of attorney. It's really a personal decision. I mean, if people do have folks in their life and they're trustworthy, and if the friends or even acquaintances are willing to serve, you know, I had a client who was estranged from from all of her children, but her rabbi served as her agent under a power of attorney because he felt that it was his duty to serve his congregants. So it's a very personal choice, but for people who don't have anybody or prefers a professional, you'll have to pay the attorney who's serving as an agent, of course, but that is an option.
Great. This last one's actually my question, but it might be relevant to other people as well. I was actually wondering about the repayee process that you mentioned for Social Security. I'm working with a patient right now who actually wants to go through with that process, and I was curious what that process actually looks like if you go through with the repayee one.
Yeah, so the Social Security representative payee, or rep payee, I call it a lot. So if you want to, maybe the patient that you're working with, they can there's an advanced designation, and I have the link in the resources slide at the bottom, but I'll just talk about it a little bit. You can advance designate somebody with the Social Security Administration who you would want to serve as your rep payee when you need it. Or if the person is already at the point where they can't really manage their benefits independently, the way the representative payee process works is that the person who's going to serve as your rep payee goes to you make an appointment with your Social Security office. Usually, I don't know if it's changed with COVID, but I think there are offices that are still doing this. But they always want to have like an interview with you and the person that you're going to manage the benefits for. And you also need a doctor's note. And I'm pretty sure that, the clinicians at Penn Memory Center could certainly attest to this person lacks capacity. This is their diagnosis. This is their functional level at this point. And that's mostly what the Social Security Administration needs to make you the representative payee. And then when the benefits are, the benefits will be, I don't know if people make their own, because we don't help people go through this process. We always direct, because the Social Security Administration has to do it. But it will be deposited into either a special designated account or into the account of the person who's serving as a rep payee. But those funds do still have to be spent on, the incapacitated person.
Thank you. Okay, that is all the questions. Thanks for those who put them in so far. Please continue to do so. Someone also sent one anonymously to me, and if you'd like to do that, please feel free to just send your question as a direct message to me, and I'm happy to share it out.
All right, thanks for raising attention to the questions. Thanks to folks for asking the questions. Sorry, I'm losing my voice a little bit, so I hope you guys have more questions so I can rest my voice a little bit later. So now we're going to switch away from I'm nearing, sort of more the end of my presentation, and we're going to get to a case scenario that may be of interest. But let's talk really briefly about some other common legal concerns besides guardianship and advanced planning that we see at Senior Law Center with families who have dementia or experiencing dementia. So sometimes we see housing issues that arise, like evictions or foreclosure actions, maybe because the person hasn't been paying their bills on time or things like that, having trouble with financial management. So we defend in those types of instances, defends against the eviction or foreclosure. Unfortunately, caregiver abuse, exploitation, neglect, or just scammers, consumer fraud, romance scams. There's all types of ways that very sadly, older adults are often targeted, and especially if you're experiencing dementia, that may occur. So we represent people who have been victims of those types of neglect, exploitation, abuse. We do, we're also aware that the topic of self-neglect, quote unquote, can be really controversial, and is self-neglect really a thing? So it's something that our victim services teams sometimes have to encounter and deal with. Another common request that we get at Senior Law Center is questions about Medicare and Medicaid planning and benefits like Social Security disability insurance, and also SSI, which is supplemental security incomes for folks with low incomes and disabilities. We don't do benefits work. There's other organizations in Philly that does that, and the Medicare and Medicaid system is incredibly complex. I do have some working knowledge of both of those things through exposure through my own work, but Senior Law Center doesn't counsel on those. But qualifying, so an example is let's say you have a middle-class family and there's a diagnosis, and they're thinking ahead to, how do I stay in my home, or how do I go to a facility? I mean, these things are incredibly expensive. Like paying a private home health aid, especially as your number of hours increase, is incredibly expensive, and also a facility is. So many people hire a private lawyer to engage in Medicaid estate planning, where you're going to talk to the lawyer about spending down. That's spend down your income in a particular type of way, like set aside assets for burial. Like I was saying, there's other ways to protect certain assets, but then you basically are going to spend down your income on the care you need until you reach the level where you qualify for Medicaid, which in Pennsylvania is also called medical assistance. So that's a common way that people want to engage in planning. And for people who are committed to staying home and receiving in-home care, even if you can't afford to hire your own private caregivers, you can receive what's called waiver services at home. It's called Community Health Choices Waiver Services, or Home and Community-Based Services. That's the official name. So for those wishing to receive care at home instead of a nursing home, And I just wanted to note though, that if somebody's receiving state funded, paid or state funded caregiving at home that's funded through Medicaid on these waiver services, your paid caregiver cannot be your spouse. The paid caregiver cannot be your agent under a power of attorney or your rep payee or your legal guardian. So sometimes that does become an issue. If say there's an adult son who lives with his dad who has dementia and he wants to get paid to take care of his dad, unless you're doing it via a private pay arrangement, if you're going to get funded through the state partially and go through a home health agency, then you can't have certain relationships. Like the son could not be the agent under power of attorney. Okay, so those are some of the most common issues in addition to the guardianship stuff that we see when folks are facing dementia. I have a case scenario next, and Rachel, we had paused for questions, so there's probably not any questions after that one slide. But I'm going to go ahead. If there is, let me know. Okay, I know this is a lot of text, and we'll see if you guys want to engage with this case scenario at all. But we have Adrian. Obviously, this is a made up person. This is a composite of things we see all the time. So Adrian is a 70-year-old man. He has diabetes and mobility limitations. Adrian lives in a generational home that is titled in both of his parents' names, and both of his parents are deceased, but he's living in the home. Adrian's wife passed away last year after an illness. Now he lives alone. He doesn't have a big circle of support. He used to attend church services more regularly, but not since COVID. He was recently diagnosed with mild cognitive impairment, MCI. He doesn't have any legal planning documents in place except for a will that he made in 1980. He has 2 kids. His adult son lives locally, but they're not on very good terms. His adult daughter lives 2 hours away. His income, he receives $1,800 monthly income in Social Security. He was employed as a postal worker for most of his career, and his life savings amounts to about $80,000. He has a modest life insurance policy, but he can't remember the status of that. Can't find the paperwork about it. He doesn't have any current forms of ID. His driver's license is expired. So now we're at the point where his adult son, who lives locally and they're not on good terms, his son is alarmed by Adrian's decline since his wife's death and wants his dad to move into an assisted living facility and sell the house or transfer the house into the kid's name so that the nursing home doesn't force him to sell it for payment. That's what he thinks is going to happen. Meanwhile, the daughter is urging Adrian to make her a joint account holder of his bank account so that she can monitor his finances and help him pay his bills. So this is an example of like, if we go through an intake with somebody maybe, and we collect all this information. So put on your lawyer hats, put on your law school hats. And I'm curious if anybody, and Rachel, you can also jump in if everybody's shy and doesn't want to talk, I can like go through a few things maybe, but I would love for people to tell me what stands out to you about this. What do you see any red flags? Do you see anything that doesn't really make sense or that you would want more information about, or do you have any ideas about how to assist Adrian here? What do you think should happen? Give folks a couple minutes to just read and think about it. Does anybody want to chime in? Rachel, I'm going to put you on the spot. Do you see any like red flags or anything that you want to talk about?
Well, I see that he has no other legal documents in place other than the will. And so I would think that, trying to figure out what to do about the health, like a power of attorney and healthcare proxy at this stage would be good.
Yep. Do you think that all we have about his cognitive capacity right now is that he was recently diagnosed with mild cognitive impairment? If many people with MCI are still able, it's early in the process, so let's say that he would be able to have the capacity to implement those documents. he should definitely, we would want to help him put documents in place, revise that will, just redo the will, to be honest, and put other legal planning documents in place. Certainly, we would want to do that. What about his house? Oh, so does somebody want to say something?
Yeah. Can you hear me?
Yes.
I think he should see someone from his church, someone who knows him that could work with maybe him and his doctor. And I think he should also get some legal help.
Yeah, 100% agree with you. Reaching out to those support networks, the church, that's a really good idea. Reconnect with the church. He's going to want some more support in his life as things progress. And yeah, seeking out the help of a lawyer, not only to do the legal documents that Rachel and I just talked about. There's a couple other legal issues in here. Thanks for chiming in, Joanne. Does anybody else want to comment on anything? Go ahead.
Yeah, I've got a question. I'm assuming is his concern thinking somehow that he's going to have to sell the house as part of getting rid of assets? I mean, usually to be able to cover it such that Medicaid kicks in, is that what he's trying to avoid? Because if so, he's potentially, depending on if he wants to send them into a nursing home now or assisted living, he's going to have to deal with the look back period for Medicaid or whatever, and it's going to count as most likely count as a transfer.
Yes. There's a couple issues with the house, but yes, thank you for raising that. First of all, the house isn't even in Adrian's name, it's in his parents' name. That's something we see a ton. It's called tangled title. It means the title to the house is like tangled in the generations. So Adrian, I mean, he has been living in the house. I'm not a housing attorney. I know that there's a housing attorney could go to town on this, but that's an issue that the house isn't even in his name. But if the lawyer were to help him untangle that title and get the house into his name, which I'm actually doing with a client now. So let's say that the house was in his name. Yeah, there is an issue. And actually the issue with having that asset may need a discussion about whether you even want to put the house in his name. But for most people, having a house, your sole residence usually doesn't count as a resource when you're trying to qualify for benefits. But if you weren't intending to return back to that house, then certainly when it's sold, that money would be used to pay for care. And there is a look back period, as Christina said, of even if you're doing advanced planning now, it's a 5-year look back period in Pennsylvania. So any large transfer that you made within the past 5 years, the government is gonna, if you're trying to qualify for Medicaid, the Department of Human Services is gonna look at that and say, you made this transfer within the past 5 years, like we're entitled to that money. You must have done that to avoid paying, your fair share. So this is a really good reason why consulting with an experienced estate planning lawyer, and again, we don't do benefits like advanced Medicaid, Medicare, we do these basic life planning documents, but we don't do the extensive like Medicaid advanced planning type of stuff. But that's just an issue that I wanted to flag because don't assume that, there's a lot of laws out there and you really need a lawyer to help you sort through what all the issues are and how to best plan ahead so you don't accidentally do something that puts you in financial jeopardy. What about the daughter making the daughter a joint account holder? What do people think about that? So I will say it does, some people have done this. Oh, go ahead, Joan.
On that, my husband just said that he should make her the rep payee because then she'd have to prove that she's spending the money on him.
Yeah, that's a great idea. So yeah, he has $1,800 a month in Social Security income. There's no other income listed here. She should be the rep payee and not making a joint account holder. The problem with a joint account is that, and many spouses do this, and there's absolutely nothing wrong with it. But it can really be an avenue for financial exploitation, unfortunately, even among family members whom you think are trustworthy. Making somebody a joint account holder means that they own that money too, and they can drain the account and you can't sue them for it. You can't go after them. you know, if you have, if he has that $80,000 in his life savings in that bank account and he makes his daughter the joint account holder, she could take a large sum out. She could take little, you know, she could take like $100 out at a time without him noticing. So you have to be really careful about being a joint account holder, and legally speaking, we don't usually recommend it, but sometimes when it exists, with a trusted person, it, you know, it can be a way to monitor. But she can also do a view only designation with her bank, but I think the rep pay is a great idea here.
Can I ask a question regarding that? Okay, if you have been diagnosed with early stage Alzheimer's and a husband and wife have a joint account,
Mhm.
is it a good idea? What should be done with that account?
So if you already have a joint account as spouses going into it, there's no reason that that needs to be changed. I mean, you know, the spouse can still be the rep payee, or actually, you know, even if the Social Security is getting deposited into that joint account, you don't even need to be a rep payee because you already have access, you know, both parties already have access to the money to be able to manage it. A rep payee is really needed when the account is owned like solely in the person who has Alzheimer's. So yeah, there's no reason to get rid of that joint account. Of course, I'm not like a financial advisor, but my initial reaction is that there's not a problem with having that joint account there. If that's worked for you in the past is managing money. We just want to caution people against adding, you know, somebody like once a diagnosis happens, especially if there's like a new person in somebody's life who's like maybe a little suspicious, like not adding them to the joint to a joint account. But yeah, there's a long-standing arrangement where you guys have managed your finances jointly. Can certainly keep doing that.
Can I ask a follow-up
Thank you.
question?
Yeah. Yep.
Just as a follow-up with that, from what I'm just Googling really fast, and so the rep payee seems, and I understand that in this hypo, we're just, all he has is a social security income. But
Mhm.
let's assume if someone has a pension or something coming from a state, everything I'm reading talks about a rep payee thing being something being something determined by the Social Security Administration. Can you do something similar with all your other retirement accounts? Because for me, I just have power. My mom 20 years or 15 years ago totally trusted me and gave me a full power of attorney. So I have everything I need. But I'm just wondering, but I also don't write checks in mine. I don't sign the checks, you know, I sign her name.
Mhm.
And so I'm wondering, is there something like this you can do with state pensions or something like that as well?
Yeah, that's a great question. So you're correct. Rep payee is only for Social Security income. But for things like pensions and if you're getting income from other sources, a power of attorney, if it was executed, you know, here Adrian is early in his mild cognitive impairment. If we're able to get those documents in place, then it won't be an issue. But he, like a rep payee won't be able to, you know, serve as an agent for anything else. So if there wasn't a power of attorney in place, that would become a problem down the road if the pension company, if the, you know, whatever it is, insurance company, the state needed an authorized agent to talk to and there was no, you know, power of attorney in existence already, then that's an issue. And that may require guardianship, unfortunately, if there's an issue that has to be dealt with before his death. Does that answer your question, Christina?
Yeah, thanks. That's sort of what I was figuring out, because I was sort of trying to figure out what the best way is to be able to sign checks without
Mhm.
necessarily becoming a joint hold, like signing
Yeah.
my name.
Well, if you're an agent under power of attorney, you know, people, it's just best practice to like sign the, you know, your name like as agent for so and so, or, you know,
Oh, okay.
there are actually the Consumer Financial Protection Bureau, the CFPB, has a really great series of guides called Managing Someone Else's Money. And I put some other CFPB links in my resources slide, but you might want to look at that, Christina. So Managing Someone Else's Money, they have
Thank you.
them even tailored for individual states. I actually worked on the Pennsylvania one when I was a law student intern with Senior Law Center back when. But they also have just a generic one, and I think it will cover that. But I know that there's a wealth of information out there if you just want to Google, like, you know, I mean, I guess I should be cautious about that. You don't want to just take anybody's advice on the internet about how to do it, but if you find a reputable thing like the CFPB talking about the best way to serve as an agent and, sign checks on behalf of somebody else.
Awesome. Thank you.
Yeah, you're welcome. So I put a slight, in true law school fashion, we're gonna put a slight remix into this. So let's pretend, and this is, I think, my last slide before before I do resources, and we can open it up to other questions. Let me just check on that. Yeah. So after this, I'm just going to talk about some resources for everybody and see if there's any last questions before we head out. But let's say now that instead of having being early in his diagnosis of mild cognitive impairment, Adrian actually had a serious stroke and he's in the hospital. He's not able to understand or communicate anything. His speech is very, garbled, and he doesn't appear to really understand what's going on. So he's in the hospital, pending admission to a rehab facility. Everything else is the same, except that, his son Adrian now wants him to move to a nursing home permanently. He wants the house to be sold. The daughter's still looking for a way to monitor his finances and pay his bills for him while he's in the hospital. So now that we have this change of facts, is anything that we talked about different, or does anybody see issues? Christina, what we just talked about might see an issue with what we were talking about, putting documents in place, right?
Oh, yeah, he's got, for a POA is out the window.
Exactly. Yep. So nobody can quote unquote get a POA for him. Unfortunately, at this point, he has, unless he recovers and truly regains capacity, at which point he might be able to implement those documents. At this point, he does not have the capacity to redo his will or to put any other documents in place. So let's, for his hospitals need legal authorization to discharge you to a rehab facility. Who in this scenario can make, how is that going to happen here? Can anybody step in and give the hospital the legal authorization to admit him to a rehab facility?
I guess I'm thinking that I know that it goes, if it's spouse first, you said, but spouse is not available here.
Mhm.
So I guess it would be one of his kids, but I don't actually remember if you said if there's a hierarchy of the children.
Right. It's adult children, adult child. It's also whoever's most available sort of, but in this case, the hospital would look to one or both of the children as healthcare representatives, and those, one or both of the children could authorize his admission to a rehab facility as his healthcare representative. So that at least solves that problem. How about his managing his, says the daughter is looking for a way to monitor his finances. Can she serve as a rep payee? That's a trick question. She can. Actually, I should have, in the other scenario where he only had mild cognitive impairment, I slipped my mind, but I just want to point out that you can't actually become a rep payee you need the doctor's note saying that this person is incapacitated. So actually, in terms of when I was talking with Joanne about it, if Adrian in the previous scenario where he only had mild cognitive impairment, his daughter could not become a rep payee at that moment, but Adrian could certainly advance designate her. He could designate her in advance to serve as the representative payee when he needs help managing the money. It's still, maybe if he trusts his daughter greatly and really feels that he wants to put her on the bank account as a joint owner, that's his choice. It is legal, but again, not super advisable. But at this point, with him having a serious stroke and being incapacitated totally, he would certainly be able to, his daughter would be able to serve as a rep payee. She and her brother can work out. We're presuming that it's her in this case who would serve as the rep payee.
Well, I was going to say, if you've got two kids who are at opposite ends of the spectrum with what they want to do with their father's money, and he's not necessarily in a position to communicate decisions. So how does the Social Security Administration decide who they appoint? Or who
I guess the person who would want to become the rep payee sort of submits themselves, and the Social Security Administration like vets them to do that. I don't know what they do when there's two siblings coming to them fighting it out, but I will say that in guardianship issues, sometimes things do progress to a guardianship simply because the family cannot agree. And that, you know, it's really challenging. So it's unfortunate because, like, yes, the person's incapacitated, but a guardianship doesn't seem like it's necessary because there are surrogate decision makers there's alternatives, but if they can't agree, then sometimes a guardianship is needed. Yeah. I wish I knew more about the Social Security, like how that process works, but I haven't. The Social Security Administration, I'm sure some of you have noticed, has been really difficult to get in touch with and go in person. So, but yeah, I would be interested to know more about that. Maybe Rachel or some of the other like social work folks at Penn Memory Center have more insight into Social Security rep pay stuff. There's the same issue here with the house is still in his parents' names. The difference here is that the lawyer, so you're not going to be able to put the house in Adrian's name if he doesn't have capacity. That's a problem because like he would need to serve as the executor or the administrator of his parents' estate and retitle it. Unless maybe Adrian has a sibling, but we didn't put that in here, but who could do that instead. But basically, since he doesn't have capacity, that house is not going to be in his name anytime soon. So that's an issue. I didn't mention, I think expired driver's license, and if he wants to get benefits, including like home health aid. I have so many clients who don't have current licenses. There is a way through PennDOT to have if somebody's bedbound in a hospital or a nursing home, PennDOT can just issue if you already had a license or a photo ID, they can like reissue it with the old photo. But lack of photo ID is a real problem, real sticking problem in legal aid sometimes. So we only have a couple minutes left. Let's share the last couple of slides. Just go through. Oh wait, I'm on the wrong screen here. Okay, finding a lawyer. This is the information for Senior Law Center. We have our free confidential helpline statewide for adults 60 and over. This is important. We only talk to the older adult who's having the legal issue. If a well-meaning, family member calls, caregiver, unless you're with the adult and they can go through the intake themselves and they have the capacity to do that, we're not going to be able to talk to you. But we can give referrals to third parties who call in, that includes, like I said, caregivers, family members, but usually we want to be talking to the older adult who's having the legal issue themselves, because we need to make sure that this person is seeking out our services. And unfortunately, there's a lot of cases where a family member might call us and have less than good motives and want a lawyer to do something for them. So that's part of the reason why we want to make sure that the older adult is seeking our services. But if in doubt, you can still call in, listen to our phone tree system and leave a message. We certainly give you some referrals if we can't deal with you directly. We do have on our website our Philadelphia and Pennsylvania legal resource directories. The lawyer referral service, this is what I was mentioning earlier. This is the information for the Pennsylvania Bar Association lawyer referral service. They're on their website, they have a listing of the lawyer referral services for each of the counties, and I use that all the time when referring people in Pennsylvania in different counties. So again, it'll connect you with your local Bar Association's referral program. You can have a 30-minute consultation for under $50, varies by county. There's no obligation to hire the lawyer. Some bar associations, including Philadelphia is one of them, has a modest means program, where if your income is not low enough to qualify for legal aid, but you also, can't afford to hire a private attorney, there's some modest means programs where this includes advanced planning documents, by the way. You can get them done for a really cheap, relatively speaking, flat fee. So that's worth looking into with your local bar association, asking them if you don't qualify for legal aid, if there's a modest means program. And then you can sometimes find free legal assistance through law school clinical programs, attorney pro bono assistance, but I would probably recommend, if you need free legal assistance, you really can't afford it, calling our senior law helpline, at least talking to a lawyer about the issue. And if we can't directly help you, maybe because we don't serve your county or something, we can provide you with referrals. So that's finding a lawyer. And like I said, I think every state has this. So if you don't live in Pennsylvania, or your family member doesn't live in Pennsylvania, certainly check out the similar service in another state. Here are some other resources. The Center for Advocacy for the Rights and Interests of Elders, CARI. Senior Law Center, we actually share office space with them. They're mainly advocates and social workers. They're not staffed by lawyers. They also have a free helpline, and it's available to everyone. I emphasize that because I mentioned that we as a legal organization have some limits on ethically speaking on who we can talk to as a client. But CARI, anybody can call, and it's actually anybody nationwide. But I don't know how many people nationwide call, but if you're a caregiver, if you're an older adult, if you're a family member, if you're just like an acquaintance, you can still call CARI and talk about whatever issue you're having. So that's their free helpline. You can always go to your county area agency on aging or AAA to connect to services for older adult. And that's also where you would report elder abuse in the state of Pennsylvania, is the Older Adult Protective Services, which is within the area agency on aging. If you or a loved one are having issues with care, the level of care, or the whatever it may be at a nursing home or a hospital or any other type of care facilities, there's the Long-Term Care Ombudsman Program. So that's the Pennsylvania statewide number for it. When you call that, they're gonna give you the number of the agency that staffs, the location where that nursing home is. So I often refer people who are in nursing homes to the Long-Term Care Ombudsman Program because maybe they don't actually really have a legal issue in the nursing home, but the care is terrible and they're not getting their medication or something like that. That's when the ombudsman can step in as either a staffed ombudsman or a volunteer and be an advocate for the resident of the nursing home. And anybody can make that inquiry to the ombudsman. Like, even if you're a family member, you don't have to be the resident of the nursing home to make that request. And then I think this is my last slide. Yep. Some online resources, and this I really intended for folks looking at afterwards when you get the PDF. These are all really good links. So Senior Law Center, we do have our guardianship FAQs. This is right here. I bolded it. I did put those together. They're very extensive. It includes alternatives to guardianship. So there's, honestly, my presentation today covered a good deal of stuff that's in there, but I don't often have the opportunity to talk to folks for this long. So this is a really great resource for Pennsylvania guardianship FAQs. Like I said, we have our legal resource directory, and then here's a bunch of other stuff, some by the CFPB, as I was talking about before, which has those managing someone else's money guides, but they also have tips for considering a financial caregiver,